This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So we've done a whole series of videos about how Prenda Law, Paul Hansmeier, John Steele, and the late Paul Duffy set up a copyright trolling honeypot scheme where they literally made their own adult movies and put them on the internet in order to make them available for download on pirate websites like the Pirate Bay. And then they would sue the people for copyright infringement, despite having put those files on the internet themselves. It's one thing if you're a legitimate, good faith, sincere copyright creator and someone steals your stuff. That's fine. I respect people who defend their ownership of their copyrights. When you don't sincerely put your copyrights out there for sale, but instead make them so that you can just seed them to torrents and then sue people, now you're a copyright troll. And when you do it that way, that's some kind of fraud. And that is what Paul Hansmeier and John Steele were convicted of. Paul was the ringleader. I think he was sentenced to 15 years, and John Steele was sentenced to 5 or 6 or something like that. Well, they're back. Paul Hansmeier has filed a lawsuit seeking a declaratory judgment and injunctive relief, allowing him to restart the Prenda Law copyright troll honeypotting scheme from prison. And he handwrites in the United States District Court for the District of Columbia. Plaintiff Paul Hansmeier seeks to enforce copyrights via the method used by the plaintiff in Olin Mills, Inc. v. Lynn Photo Company. Hansmeier cannot do so, however, without facing a credible risk of criminal prosecution. In this action for declaratory and injunctive relief, Hansmeier respectfully requests that the court enjoin defendant William Barr from pursuing Hansmeier and those assisting him for fraud or extortion for enforcing copyrights via the Olin Mills method. Plaintiff Paul Hansmeier is a citizen who is currently an inmate at the Sandstone Federal Correctional Institution in Sandstone, Minnesota. He requests that this complaint be afforded the liberal construction given to complaints filed by pro se prisoners. Oh, he will. Remember Edward Thomas Kennedy? He is getting the Edward Thomas Kennedy treatment. And just hang on, you're going to see it. And so he has sued defendant William P. Barr for a declaratory judgment. Hansmeier seeks to enforce copyrights via the Olin Mills method. For now, just imagine honeypot. He will retain an investigator to make his copyrighted works available to suspected infringers via notorious digital piracy websites. File a complaint in the form of an Exhibit A, here too, so he's got an Exhibit A, against users who copy the work from the investigator's computer, and C, attempt to settle the claims or, if necessary and appropriate, pursue a judgment against the infringers. Hansmeier faces a credible risk of criminal prosecution if he does this. In late 2016, defendant charged Hansmeier with mail-in wire fraud based on allegations that Hansmeier used the Olin Mills method to enforce copyrights, but concealed his use of the method and his involvement in the copyright enforcement actions. No. He was convicted of mail-in wire fraud because you can't cede your own copyrights to the internet and then expect to be able to sue over them, let alone that he obtained Alan Cooper's consent or signature fraudulently, and that he improperly had a defendant throw himself under the bus in order to get a court to agree to subpoenas of thousands of other defendants in the same case. So you get one defendant to consent to a judgment against thousands of others, or rather consent to subpoenas against thousands of others. So that's why he was convicted of mail-in wire fraud. In addition, defendant alleged that related claims that Hansmeier brought pursuant to the Computer Fraud and Abuse Act were entirely invented claims of hacking into computers that did not exist, which, yes, that was more or less true, that Hansmeier did entirely invent those computer fraud claims in order to pursue people under the Computer Fraud and Abuse Act, which is an alternative, not really a legal alternative to, so copyright infringement is not automatically a violation of the Computer Fraud and Abuse Act, but breaking into a computer, username and password, hacking kind of thing, that could be a violation of the Computer Fraud and Abuse Act. So you could have both, but he alleged them as if everybody who committed copyright infringement on the Pirate Bay was also violating the Computer Fraud and Abuse Act. The allegations in the indictment are publicly available on the docket of Hansmeyer's criminal case. Hansmeyer's challenge to the legal sufficiency of the indictment is pending before the U.S. Court of Appeals for the Eighth Circuit. In his appellate response brief, defendant indicated his position that Hansmeyer's use of the Olin Mills method to enforce copyrights also constitutes extortion. Yes, what is extortion? Extortion is demanding relief, demanding a payment or a performance of something, so demanding a benefit when you don't have a right to a legal claim. So if I have a copyright claim against you, well, I can demand $1 million, and that's just my demand. That's not extortion. But if I don't have a copyright claim and I say, well, I'm going to sue you for copyright infringement anyway, give me money, that's extortion. And that's what Hansmeyer did. He didn't have a copyright claim, and he kept pursuing the defendants anyway. In his anticipated cases, Hansmeyer will proactively address many of defendants' allegations of wrongdoing. Specifically, as the form of complaint attached here to as Exhibit A demonstrates, in his anticipated cases, Hansmeyer will be named plaintiff, and the complaints will detail Hansmeyer's use of the Olin Mills copyright enforcement method. Oh God, is he going to buy copyrights to then try to enforce? Oh God. As for Hansmeyer's CFAA claim, Hansmeyer's complaints will be accompanied by an excerpt of the computer log, which forms the basis. Oh, he's doing the CFAA claim again too. Oh my gosh. The reason why the CFAA claim doesn't work is no one has broken into a computer. So what, when you download something via a BitTorrent swarm, how have you broken into a computer? These features of Hansmeyer's form of complaint will eliminate any basis for defendant to claim that Hansmeyer is concealing his involvement with the cases or his use of the Olin Mills copyright enforcement method, or that Hansmeyer's CFAA claim is based on allegations of trespass onto computers that do not exist. All right, let's back up for a second. His use of the Olin Mills method was not the thing that got him thrown in jail. His concealing of the Olin Mills method was not what got thrown in jail. His concealing of his lack of ownership of copyrights, his fraud in obtaining Alan Cooper's signature, his fraud in obtaining the defendant's consent, those were the reasons. Hansmeyer's anticipated cases will not completely eliminate defendants' problems with Hansmeyer's copyright enforcement methods. Critically, Hansmeyer's cases will continue to involve the use of the Olin Mills copyright enforcement method. Because his anticipated cases will involve the Olin Mills copyright enforcement method, Hansmeyer faces a credible risk of criminal prosecution. His position in this case is that the Constitution does not permit defendant to use the fraud and extortion statutes to chill Hansmeyer's anticipated claims. Chilling is a word for free speech, and there's no free speech here, but whatever. Rather, if defendant disapproves of Hansmeyer's anticipated claims, then he is entitled to seek court permission to intervene in Hansmeyer's civil cases to present the United States interests. Yeah, so he's saying, if I'm committing what you think is fraud, instead of charging me with fraud, you should just intervene in my civil case. It would have been so much easier if you had just intervened in my civil case. Yeah, I'm sure that no one from the Department of Justice ever gave him a chance to pull this one back before he got charged. In summary, then, Hansmeyer seeks to bring claims for copyright infringement and violations of the CFAA. He has previously been prosecuted. He cannot bring his claims without facing credible risk, cannot retain or consult with legal advisors without facing a credible risk. What? No, he can retain or consult with legal advisors. He just can't do it. Hansmeyer cannot retain or consult with investigators. Yes, he probably, well, maybe he has terms of his sentence that mean he can't do that. But otherwise, he's not enjoined from it that I know of. Hansmeyer cannot communicate with defendants or attempt to settle his claims for copyright infringement without facing a credible risk of criminal prosecution. Okay, maybe there is. I'll have to look and correct myself on the video that we drop. Maybe there is some kind of violation of his terms of sentence. So he alleges a right to petition the court. So he calls it a First Amendment claim that Congress shall not make any law abridging the right of the people to petition the government for a redress of grievances. The government's application of the mail fraud, wire fraud, and extortion statutes to his anticipated copyright claims impermissibly interferes with and prohibits the speech necessary to access the courts. Defendant's application of mail fraud, etc., is not justified by a compelling or legitimate government interest. He's trying to cover all his bases here. Let's see here. He alleges freedom of speech. He wants the law declared void for vagueness. He uses this separation of powers defense. That's one I have not seen but once before, I think. So Article 1, Section 1 of the U.S. Constitution vests legislative power in Congress. The legislative power is to make the law. They've enacted the CFAA, and so therefore he's saying the courts can't overrule his ability to use the CFAA. Okay, so he's asking for all of that, and he makes an application about being a pauper, a person who needs to proceed in forma pauperis without paying fees or costs. He requests a summons, and he writes a 45-page memo, which we're not going to go over. Maybe I'll look at this separately and pick out what I want in here, because this is already going to be quite a long video, because we still have a little bit to go. Let's take a look at the Olin Mills case. It's actually a relatively short case, so let's just power our way through it. Olin Mills appeals from the district court's grant of summary judgment to Lynn Photo in this copyright infringement case. Olin Mills also appeals the denial of his motion for an injunction prohibiting Lynn Photo from future infringement. We reverse the entry of summary judgment for Lynn Photo, direct the district court to enter summary judgment in favor of Olin Mills, and remand the questions of statutory damages, injunctive relief, and attorney's fees. Olin Mills operates more than 1,000 portrait studios in the U.S. Lynn Photo sells photographic equipment and supplies, develops print and slide film, etc. In mid-1986, Olin Mills discovered that Lynn Photo was engaged in unauthorized copying of photographs to which Olin Mills held the copyright. Olin Mills contacted Lynn Photo and requested that Lynn Photo cease this activity. In 1987, Olin Mills took a number of photographs of its employees and their families. They registered the copyrights in 4 of these photos. Olin Mills then hired a private investigator to conduct an investigation into Lynn Photo's allegedly infringing activity. On 4 separate occasions, the investigator ordered reproductions of the copyrighted photographs from Lynn Photo. Despite the fact that the photographs were clearly marked with a copyright notice, Lynn Photo made the reproductions and the investigator paid for them. For at least 3 of the requested copies, the investigator signed a permission to copy agreement, which provided, "This is to state that I am the owner of this photograph and I have not given anyone else permission to copyright this photograph. I am submitting it to Lynn Photo Company for a copy at my request. This copy is for my personal use, and I agree to hold harmless Lynn Photo Company or any of its agents from any liability arising from the copying of this photograph." Olin Mills filed a suit in federal district court alleging that Lynn Photo's activities infringed their copyrights. Olin Mills requested statutory damages and an injunction prohibiting Lynn Photo from future infringement. After discovery, the district court granted Lynn Photo's motion for summary judgment on the grounds that the investigator licensed the copying. The district court also awarded attorney's fees to Lynn Photo. So the district court concluded that the indemnity agreement was enforceable, but the court disagrees. Lynn Photo's indemnity agreement does not constitute a good faith effort to avoid copyright infringement. Therefore, Lynn Photo cannot rely on that agreement to avoid statutory liability. A purchaser may own a copy of a photograph, but absent specific arrangements to the contrary, the copyright remains vested in the author of a photograph, here Olin Mills. Because the photographs in this case were clearly marked with a copyright notice, Lynn Photo could not reasonably rely on its indemnification agreement. I'm thinking of a scenario where it says copyright owned by Olin Mills or something like that, and then the investigator goes in and his name is Joe Smith and he signs it Joe Smith, so why would they have any reason to believe that Olin Mills authorized him to make a copy? So that's what they're saying there. Let's see why they remand first. In summary, we conclude that Lynn Photo infringed on Olin Mills' copyright and that Olin Mills is entitled to statutory damages for the registered photographs. We thus reverse and remand to the district court for determination of appropriate damages, consideration of injunctive relief, and attorney's fees. So that means that yes, your private investigator can test the system and see if there's a violation. So then the question becomes, can Paul Hansmeier cede a torrent of a copyright that he owns to the Pirate Bay and then sue you for it if you download it? And I guess that has yet to be seen, but I have a very strong argument that that is an implied license or unclean hands. There are lots of things on the Pirate Bay, many of which are not infringement of copyright or aren't violative of any law. Yes, there are a whole bunch of copyright infringing files on there. But if you go and click on a torrent file that has been seeded by Paul Hansmeyer's investigator, is that not some kind of unclean hands, which gets rid of your right to relief, or some kind of implied license, which means you gave permission and therefore have no further right to relief, or some kind of not just implied license, but an express license. You put it there for people to download, knowing that that's what it does. So if let's try to put this into a physical world scenario. Let's say that you have one of those like news stands, like, free take one, except yours doesn't say free take one. If you put something on your website with a link, and anybody who clicks on the link can download from you, they're downloading it from you. You've given them permission. If Paul Hansmeyer puts something on the Pirate Bay, who is seeding, who is providing the first bits, the first parts of that file, but Paul Hansmeyer? You're providing it. Someone's computer goes, do I have permission to download this file? And you go, yes, I have permission to download this file. That's literally how an HTTP GET request works. BitTorrent is not an HTTP GET request as far as I know. It's a similar request. So definitely defense attorneys are going to be able to argue against the Olin Mills method being applied to a BitTorrent swarm. Well. But we don't have to get to all of that because the judge has done it for us, recently dismissing the Paul Hansmeyer case. This matter brought pro se is before the court on review of the complaint and the plaintiff's application for leave to proceed in forma pauperis. The court will grant the in forma pauperis application and dismiss the complaint, because the law requires an immediate dismissal of a prisoner's action upon a determination that the complaint fails to state a claim upon which relief may be granted. This is the Edward Thomas Kennedy treatment. This is what keeps happening to Edward Thomas Kennedy and Amro El-Ansari when they bring federal pro se in forma pauperis actions. The court just dismisses it under 28 U.S.C. 1915a. A complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Plaintiff is a federal prisoner incarcerated at the Federal Correction Institution in Sandstone, Minnesota. He wants to sue individuals for copyright infringement, but allegedly faces a credible risk of criminal prosecution for fraud and extortion in connection with bringing his copyright enforcement cases. Apparently, this would add to plaintiff's indictment in late 2016 for mail-in wire fraud based on similar enforcement conduct, which he moved unsuccessfully to dismiss. The indictment in this criminal case against defendant Paul R. Hansmeyer charges him in 18 counts, including 1 count of conspiracy to commit wire fraud and mail fraud, 5 counts of mail fraud, 10 counts of wire fraud, 1 count of conspiracy to commit money laundering, and 1 count of conspiracy to commit and suborn perjury. Plaintiff wants this court to enjoin U.S. Attorney General William Barr from pursuing plaintiff and those assisting him for fraud and extortion for enforcing copyrights via the Olin Mills method. The Olin Mills case, as we just saw, upheld an investigative scheme of a copyright holder that merely provided the suspecting infringer an opportunity to infringe upon 4 clearly marked copyrights. The Attorney General has absolute discretion in deciding whether to investigate claims for possible criminal or civil prosecution, and, as a general rule applicable here, such decisions are not subject to judicial review. Those words, absolute discretion, is not just hyperbole. That's a legal standard. Absolute discretion means, literally, absolute. He gets to decide, yes or no, whether you file cases or not. And that's it. That's the person who decides. That's the entity that decides. I mean, in practicality, he assigns policies, and then other prosecutors have discretion to make similar decisions. But the Attorney General has the ultimate discretion, and that discretion is absolute. An agency's decision not to prosecute or enforce, whether through civil or criminal process, is a decision generally committed to an agency's absolute discretion. In the Nixon case, they acknowledge the executive branch has exclusive authority and absolute discretion to decide whether to prosecute a case. Therefore, plaintiff has stated no plausible claim to relief. A separate order of dismissal accompanies this memorandum opinion. And here it is. It is ordered that plaintiff's application to proceed in forma pauperis is granted, and his motions to issue summons and a preliminary injunction are denied. The complaint and case are dismissed without prejudice. Plaintiff is advised that this dismissal for failure to state a claim qualifies as a strike, which limits a prisoner's ability to proceed in forma pauperis in federal court when certain conditions are satisfied. So it looks like he can't proceed except under certain conditions as a poor person. And so it looks like Paul Hansmeier can't easily just refile this without addressing whatever is in 1915G. I guess I'll pop it up on the screen here for the video on demand. So there you have it. Paul Hansmeier can go ahead and handwrite himself an appeal to the DC Circuit Court of Appeals, which I don't think is going to be giving him any more relief than this court did. So I think that's the end of the Prenda Law copyright trolling scheme, but can you believe it? Can you believe that he's still trying? He's still trying to keep the copyright trolling scheme. He still wants to do a honeypot. Honeypotting has got to be a very risky thing to do. If you do it wrong, as you see, it's mail-in wire fraud. It's usually something only the federal government does, or maybe a state government, or police in a criminal situation, not necessarily a copyright owner trying to gain a windfall from their copyrights. And that's the difference. I mean, Paul Hansmeier and John Steele and Prenda Law were not legitimate, good faith copyright owners who were legitimately exploiting their copyrights. In order for a copyright to be enforceable, you have to be using it, you have to be exploiting it. If you are holding on to a copyright and no one can have it, but you're suing everyone who has ever gotten a copy of it, I think courts look at that pretty badly. And then there's the Righthaven case where you can't own one of the rights. You have to own the whole copyright. So Paul Hansmeier is going to have to get himself a copyright to sue over, and he's not happy that people won't infringe the copyright enough. So he's going to put it on the Pirate Bay in order to fish for infringement. He wants to treat the Pirate Bay like a fishing expedition. And I don't see how that's in any way furthering the purposes of Article 1, Section 8, Clause 8 of the U.S. Constitution. But let me know what you think in the comments below. So that's our show, everyone. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal education and legal news channel here on YouTube, Floatplane, and Twitch. Thank you in the month of July to the following supporters on patreon.com/ljfrench and sponsus.org/law. We also include the YouTube members and Floatplane members in this as best we can. Special thanks to BU1 Simmons in the month of July. Thank you very much for your support. And thank you to the July $50 plus supporters: Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, HotGrillsInYourArea, Ameknight, and Brandyn Abel. And thank you to the July $5 plus supporters. I wasn't able to bring the LED Matrix panel with me, but we're going to find a way to get one and make one for our show here. I really don't want to do just a generic monitor. I want it to be something cool and technical, like a LED panel. So thank you to all of the $5 plus supporters who are scrolling in front of me on the crawl. Everyone's going to be in the descriptions of the videos that drop. I'm Leonard French, your favorite copyright attorney. I will see you in the videos this week. I love you all. Bye.